Okay, so I thought tonight we'd maybe get into administrative procedure. Okay, administrative procedure. All of us know about the bankruptcies: 1789, 1859, 1929, 1999. Administrative procedure is the codified system that governs how agencies, both directly in the government as executive departments and independent agencies, can interact with each other and with you or with your corporation. Okay? The Administrative Procedures Act from 1946, right from the bankruptcy of 1929, we had just in the 30s the creation of something like 18 administrative agencies of the government. Okay? Up until then, if we go back into history, before the Civil War, there were 11 agencies, administrative agencies created by the government. And then after this, between 1865 and 1900, we had about 6 additional agencies that came into existence. And then between 1900 and 1940, we had over 35 administrative agencies created. A bulk of them, 18 of them, created just in the 30s with Roosevelt and his Democratic Congress. We have a Democratic president now. Do we have a Democratic Congress now? Think we'll get some more agencies? I bet you we do. So with the, in 1946, they came up with the Administrative Procedures Act. And the Administrative Procedures Act was a way of just setting a standard for how these agencies can interact and how people can interact with them. And I don't know if you've ever heard me mention, or if you've heard maybe Jack mention or someone else mention, data integrity boards. Okay? The way that the administrative procedures work and the way that you are able to interact with these agencies, it's basically each agency, including independent agencies, have the capacity to serve an executive and judicial role in decision-making and in business dealings. Okay? So, for instance, the IRS has its own system of administrative procedure, under which is governed by the administrative law in general. So when any agency is interacting with the IRS, or when you're interacting with the IRS, or when you're interacting with any other government agency, these system of rules govern how you can interact with them. Okay? And last week we discussed records. Records are essential in the administrative process, and in dealing between agencies or when you're dealing with agencies. Some of the things that we'll be discussing tonight, and if you guys get to the documents, I got them up late today, so I'm sure not many of you had the opportunity to print them. But I have in there a little Administrative Procedure Act. It's basically like an encyclopedia article. It's read out of Wikipedia. And it goes over a little historical background and the basic purposes and whatnot. But there was, I forgot to highlight it, there was something of interest I wanted to mention on here. Okay. I'll read the introduction here. The Administrative Procedure Act, APA, is the United States federal law that governs the way in which administrative agencies of the federal government in the United States may propose and establish regulations. Where do all the regulations come into effect? Does anyone know? Anyone ever heard of the CFR, Code of Federal Regulations? Okay, that's the codification of all the administrative processes and how these agencies can interact with not only your corporations and you, but with other agencies as well. The APA also sets up a process for the United States federal courts to directly review agency decisions. It is one of the most important pieces of United States administrative law. The act became law in 1946. That's when the Administrative Procedures Act was passed. It was a culmination of everything Roosevelt had done up until that point with the Democratic Congress. It would have probably been perfected a little earlier, but we went into World War II right at the end of the 30s. And so the Administrative Procedure Act actually didn't get completed until after World War II. The APA applies to both the federal executive departments and the independent agencies. U.S. Senator Pat McCarran called the APA a Bill of Rights for the hundreds of thousands of Americans whose affairs are controlled or regulated by federal government agencies. The text of the APA can be found under Title V of the United States Code, beginning with Section 500. So for those of you who want to go look up the Administrative Procedure Act, I have some links in the documents that we included in the downloads for tonight. There's some definitions in there that come right out of the U.S. Code, Title V. But what I think we'll discuss tonight is the presentment process through a notary. A notary is a witness. They witness oaths. They witness signatures. They witness dishonors, acceptances. Okay? As a witness, and their actions are governed by these regulations. Okay? And as an official, their records as a second witness can basically serve to authenticate and certify your procedures. Okay? So, for instance, if you were, let's say you had a claim against someone and you wanted to do a private process as opposed to a public process. If you have a claim against someone, what is an example of a public process? A lawsuit, right? A complaint or something of that nature. A private process would be, remember we have jurisdiction A and jurisdiction B. Jurisdiction A being in the private, that's where our private process begins. Okay? Now, a notary happens to have the unique potential and capacity of serving in both jurisdictions. If you go to the California Government Code, you'll see that a notary public may perform any of their duties without the United States or without the state of California. Okay, what that means is they can perform their duties in jurisdiction A without the United States and without the state of California. Those are public entities. So they're basically saying a notary can be outside of the public and perform her duties. Okay? Now, the reason I may get a notary involved with my claim is that the notary is going to serve as my second witness to my procedure. And then I can establish public records that will back up my private records. My private records are going to be self-authenticating, like a claim. So for instance, I have a claim against Bob, and Bob owes me services or let's say $1,000, okay? So rather than just sending an invoice to Bob. Okay? Now, in the public, is sending an invoice enough for your public procedure? Not necessarily. But could I successfully prosecute an overdue invoice in court? Yeah. With no other proof other than bringing the invoice in. I don't have to have a proof that I mailed it. I don't have to have proof that there's any debt there. I could just print up an invoice, use it as the foundation of my court case, and if the opposing party doesn't answer or defaults, I'll get my remedy with just that invoice. Okay? Now, when you're operating from jurisdiction A, just an invoice isn't going to be very effective because you don't necessarily have the courts to enforce your private process. If you want to operate over here, you're going to get your judgment over here and then bring it over here. So you're going to get your judgment in A and bring your judgment into B if you want to enforce in jurisdiction B. Okay? Now, if Bob owes me $1,000 and I contact my local notary and I ask my notary to make a presentment, okay, can a notary prepare documents for you? No. They can't even prepare the documents that you're using in your process that have their name on it. That would be practicing law. So a notary cannot prepare documents for you. Okay? So if you're ever dealing with a notary and doing presentments, you are responsible for preparing all of your documents. Okay? So I contact my notary and I tell her that I want to make presentment of something without the United States and without the state of California. Okay? And I put together a letter of presentment for my notary. Okay? The title on it may be Presentment of Notice and Claim under Notary Seal. Okay, this is actually in the examples for tonight's downloads. I have them here grouped online. They're also grouped. You may have to look at them to figure out which documents go with what, but it's a numbering system. So you'll see that there's process 101, and 101 has maybe 4 documents with it, and you'll see they each have different names, but they all have 101 in them. And then step 2 of that process would be 102. And then the next process would be 201, and step 2 of that other process would be 202. So you guys, they're kind of grouped together, but I'll hopefully from what I give you here, you'll be able to distinguish what we're talking about. Do you have a question?
Quick question, just for definition purposes, what is considered presentment?
A presentment is, okay, that's actually what we're going over. So we'll go over in a little more detail. A presentment, when I approach my notary to make presentment for me, what I'm saying is I'm going to give her a claim. My claim will probably be sworn and have an oath on it, and she'll seal the oath, but that's not the only document she's going to be involved with. Okay, my oath could be my affidavit, could be my claim, could be an affidavit of obligation, which you could then later turn into a lien. But basically, so the first step of the process is my claim. I draft my claim in the form of an affidavit, and I get the notary to do a jurat on this document so that it's a sworn affidavit. Okay. Then I prepare a letter of presentment for my notary, and the way that this letter is structured is that the document is from the notary. Okay? It's to whoever you have your claim against. Okay? You could put like a regarding line in there if it is in regards to a specific account, let's say, that, or if it's in regards to a specific business dealing that you had with this person. So let's say Bob owes me $1,000, and Bob owes me $1,000 because I gave him my car. and we had a deal that he was going to pay me $1,000 for that car. Okay? So I may put on there regarding vehicle with this VIN number or something like that. And then it has a little line on here on the type of service that this presentment is being sent as. I recommend that whenever you're operating over here from jurisdiction A, the private, to make your claims, that anything and everything that comes out of A and into B needs to be by registered mail, return receipt, not certified, registered. Okay? Now, does anyone know why registered over certified?
Does it have to do with being the postmaster of your document or registering it as an asset?
It has something like that to do with it. I would say the reason why we use it is that certified is only for jurisdiction B to jurisdiction B. It's a benefit and privilege of being an entity in jurisdiction B. Okay, so if you're using certified mail, you are in jurisdiction B. If you're using registered mail, you can be in A and send it into B. Registered mail will work from the republic to the democracy. Okay? I don't know what that means.
It's never out of a safe environment. It goes from a safe to a signature to a
Oh,
carrier.
yeah. The way that it's transported is literally from one locked envelope carrier to another carrier. Every single carrier signs for the mail. It's the most secure way of sending mail through the Postal Service. There we go.
Isn't another reason why we send stuff registered is so that if we're in a court case, it actually shows up in the judge's documents and not just the court clerk's?
If you were sending your evidence to court,
Yeah, something like that.
yeah. If your evidence is coming from jurisdiction A, how are you going to send it to the court? Registered mail, under notary seal. You would literally make a presentment to the court. I wouldn't put it in the form of a claim like you're going to have the judge's house or something like that. It would just be a presentment of the evidence. So rather than the letter saying presentment of notice and claim under notary seal, the letter would say presentment of evidence under notary seal. And then the letter may say something like, I've been contacted by John Henry Smith from outside the United States for the purpose of presenting evidence under notary seal. Okay? And then there may be, typically on the presentment letter, there's going to be a statement on there about what the notary's going to do with your response. See, remember the presentment letter is from the notary. The notary is instructing the other party in this letter that any and all responses are to go through the notary. What is the notary? A witness. So the notary is going to witness their response. Okay? So, and then you may have something on there that says that if a response is not received within 10 days, 14 days, whatever timeline you want to give them. Now, typically in jurisdiction A, if we're operating in Admiralty, when I make presentment of a claim, there's a 3-day turnaround from which that claim must be answered. Okay? But if we're sending it through the mail, we have to account for 3 days out and 3 days back and a Sunday. So that's why 10 days is a very typical timeline if you're doing presentment of a claim through mail. You're giving them really only 3 days to respond. But because you have to allot for the time of the mail moving, the statement may say something to the effect of, your response to the claim is to be received through me no later than 10 days from this postmark to prevent issuance of a certificate verifying your non-response or default pursuant to my statutory authority. So, there's a statement right there in the presentment letter telling whoever you're sending this presentment to that if there is no response in 10 days, they're going to certify that non-response or that default. Okay? Now, you may also have in your notary presentment letter what would be considered defective response. If I receive anything but the money you owe me, that's a, what does the IRS like to call your responses? Frivolous? When it has no meaning to them? Like if you get a notice of lien and levy in the mail and you draw Mickey Mouse on the front of it and send it back, that's a frivolous response. Okay? So you can define in your letter of presentment what is an acceptable form of response. And that if it is not in that form, the notary is going to certify that as a witness that you defaulted. In fact, isn't a defective response the equivalent of a non-response? Right. When you get a notice of lien or levy from the IRS, is there a lien? Not yet. When is there a lien? When you don't respond. Or if you respond with Mickey Mouse on a piece of paper.
I shared this with you, Brandon, privately, but I want to bring this up to the class. If you ever get a notice of lien from the IRS, and this happened to me, just accept it for value because the response places you in honor, and they therefore do not file the lien.
And what did you do by accepting it for value?
I gained title to it. Exactly.
You control the transaction.
Yeah.
Now, if he were to write across the face of it, refused for cause, that could be considered a dishonor. And they could still perfect their lien against you. But when they sent the notice of lien and it had on there that you had 10 days to respond or 30 days to respond or whatever, as soon as that timed out, somebody certified your dishonor. And that's the lien. You'll never see that in public. They'll take the same notice that they sent to you and they'll file that into the public record. But the actual lien, which is a third-party certification of your dishonor, you won't see that in public. So, by that logic, do you ever want to put your certifications of someone's dishonor into the public record? Yeah, not unless you want to give up title to your claim. Okay? Now, so we've set the terms of the response. Okay? And we've clearly illustrated to the recipient what's going on with our letter of presentment from the notary. Okay? This is an example of an affidavit claim that may be attached to that. Now, I wouldn't actually have them stapled like this. I just did this so that I could separate the presentments, and I could work with this one, then this one kind of deal. So, this is my claim. Okay? This is just an affidavit. It'll have a jurat. It'll be signed. It'll have my signature on there, a sworn statement. Is this the claim? Or, better question, is this an effective claim? Can I enforce just this document? No. I could try, but it's not going to be very effective. It'd be like having an invoice with no signature on it. Affidavit is hearsay. So you say. That doesn't mean anything. Okay? Does anyone know when this becomes your claim?
I would think when you have the documentation on the other page that you sent and presented it.
Yeah. It would be your. Remember in the presentment letter, the notary illustrated that she would be certifying the dishonor or the non-response, right? That certificate attached to this claim is what makes this claim. The actual certificate from the notary as a third-party witness to what happened is actually your claim. But you would attach that to your affidavit. Should you send your original affidavit to the person you're making the claim against? No. Yeah, you want to keep that because you're going to take that original and attach the original certificate of protest to it. Then you've got a claim.
Is that a security at that point?
It could be. Depends what you do with it. It is a security at that point. Okay. This is actually, this first presentment in the example is a two-pronged presentment. It's actually a claim that's establishing a record. See, this is called, this one is a commercial affidavit, and it's establishing facts. If these facts go unrebutted or there's no response, then the other party is acquiescing to these facts. It's off.
Let's say you create an affidavit, a plain statement of fact. You have that notarized. You send it to your opposing party saying, if you do not respond to this within 30 days with an affidavit of your own, sworn on your own commercial liability, then you're in dishonor and you agree to the terms and provisions therein. Let's say they don't respond.
Mm-hmm.
In order for that affidavit to be perfected, you need a certificate of protest.
Yes.
Otherwise, the judge would say, what is this?
It's hearsay.
I see.
It's hearsay. It's just you say so. So
Right.
what? You say so.
Even though the other person can't produce an affidavit, doesn't matter.
What's an affidavit?
Well, I mean, they would have to say, well,
But what I'm saying is, see, it's not the affidavit where your claim is or where the power of your claim is. Because it's just hearsay.
It's
just
dishonor.
what you say.
right.
And
Right.
if they haven't, how do we know they haven't rebutted it?
I see.
See, the notary serves as a witness and is certified that they acquiesce to these facts. So it's not the list of facts that's the power. It's the notary's witnessing of their non-response to this.
Got it.
Okay?
Thank you.
So this one was actually establishing the facts about a payment. There was actually, this was like a process after we had made presentment of an instrument, a private instrument for payment of a debt, and after they had refused it and sent it back, we sent it back again making sure they knew. Did you know if you return an instrument that's been put in on a debt, you're agreeing to that debt doesn't exist, that debt's been settled. If I send a check in for, if I get an electric bill, and my electric bill is $100, and I send them a $100 check into the payment center, and they send it back, and then try to send me a bill for $100, I can dispute that. And that charge should go away because they agreed, when they sent me my check back, they agreed that there was no debt. So, just to make sure they know how commerce works, I wanted to establish some facts about that payment. Okay, so that's what this commercial affidavit is. And I also included, in the UCC, Title 9, Section 210, or Section 9210, there is what's called a request. That section pertains to what's called a request regarding a statement of account. And what it says in the Uniform Commercial Code. Now, if I were making this presentment and I was going to actually quote the UCC, I wouldn't actually quote the UCC, because who's bound by the UCC? Nobody. It's only when it gets codified into the states. So really, if I'm talking about Uniform Commercial Code Section 9-210, I'm really talking about California Commercial Code 9210. Interesting how they have the same number. But basically, the UCC was adopted by the state of California as the California Commercial Code. Okay? And a request regarding a statement of account, if you look, you can see there's basically a little statement of account on here. I'm sending them the statement of account showing a zero balance. They sent me the payment back, so that must mean there's a zero balance. If they do not rebut this with a verified statement, does anyone know what verified means? I'm sure the attorney does. Sworn under penalties of perjury. If they don't send me a rebuttal to this, saying that I owe more than $0 with a verified statement under penalties of perjury, this stands as the statement of account. Okay? And they have 14 days to respond to this. So my notary presentment letter actually mentions both documents. And I read you in regards to the claim what the notary said and for non-response. And what the notary has to say about this particular document is that your response to the request regarding a statement of account is to be received through me no later than 14 days from this postmark to prevent issuance of a certificate verifying your non-response or default pursuant to my statutory authority. So, if I get a third-party witness to witness their non-response to a request regarding a statement of account, I've now got a statement of account for $0. Not the statement of account by itself, but when this statement of account is attached to a certificate of non-response, it's a claim. I now have a claim, a receipt for a zero balance statement of account. Okay?
Brandon, would it be helpful to actually define the notary's position in the private or what they represent in the old code?
We'll get to that. Okay, so, and if you read the code, you go to section 9210, there are some elements on there that you must include. Okay? For instance, the collateral. If there's collateral secured by that debt, it must be listed on here. The creditor, the debtor, the date of the statement of account. So the date of my statement of account is the day that I send this out. So if I send this out on October 14th, this is a statement of account showing a zero balance as of October 14th, 2008. Microphone.
Brandon, I know you mentioned that as a cure for insomnia, we should read the UCC. But is there, in your travels, is there a guide? I know some people out there in the movement have written their sort of authoritative interpretation of the UCC. Are there any good ones out there that you would say, hey, check this person's stuff out regarding the UCC?
I mean, there's tons of, I mean, we'll be sharing lots of documents in the class and whatnot, and there's a lot available on the private network of the website. But what I would recommend, like there's cracking the code and stuff like that. I don't know if it actually deals directly with the UCC codes, but I think the best way to at least get a roundabout idea of what's going on in the UCC is just go through it. And I don't mean read it starting with Title 1, Section 1, Paragraph 1, all the way through to Title 9 or Title 10 or Title 11, Section whatever. What you should do is just kind of look, like go to the index of the UCC and check out, okay, Title 1 is this, Title 2 is this, Title 3 is this, Title 4 is this, and then you'll get an idea of how it's broken down. So you'll know, if I want to learn about securities, Title 8. If I want to learn about secured transactions, Title 9. If I want to know about negotiable instruments, that Title 3? 3 or 6 or 4. Warehousing and is Title 7. So it's all in there. And maybe you'll go to secured transactions and then just look at the subtitles in there. And you'll get an idea of how it's broken down so that if you're ever looking for something specific, Like, I knew I was looking for this, and I knew this had to do with secured transactions because I was looking for something having to do with collateral and a statement of account. And sure enough, there it is right there in Title IX. Okay? Alrighty, and then the last document of this presentment is Notary's Certificate of Service. Okay? Notary's Certificate of Service basically says, it's like an affidavit, just like the Certificate of Service, your Certificate of Protest, Certificate of Dishonor, Certificate of Non-Response, they're all basically affidavits that are being signed by the notary as a witness. Certificate of Service, the notary is witnessing what went into the envelope. The notary mails it. So the notary takes all of your documents, copies them, puts them in the envelope, seals it, and mails it out, and keeps a record of everything. Okay? Now, is this a public record if the notary keeps a copy of this? No. It's the notary's private record for presentments, if the presentment is coming from over here. Okay? Now, what about the... Oh, there's a question in the back. So your certificate of service, basically affidavit stating who you sent the materials to and a list of the materials you sent. The notary's record should be a copy of everything that got sent. You should keep all the originals. So you should have the original certificate of service, the original statement of account, the original affidavit, and the original presentment letter. Okay? Send copies out in your presentment and give a copy to the notary for her records. Well, actually, your notary is probably going to have to make the copies because the notary needs to sign and seal 2 of these documents. Actually, 3 of them because there's there's a jurat on one of them. So the notary's record is how we can take evidence from A into B. The notary, because the notary's certification of the records means they need to keep a copy of that record. How can they witness or testify that that's what got sent if they don't have a record of it? Okay, so keep that in mind, those of you who are notaries. You must keep a record. Keep thorough records. Okay? Now, this is the initial presentment. That's it. These 4 documents. Okay? 10 days later, guess what? Bob didn't respond. So, now remember this presentment we actually had 2 documents that the notary was certifying your response on. The request for a statement of account and the affidavit. Okay? So we've actually got 3 certificates here. Did I print all 3 of them? No, I didn't print all 3 of them, but there should be 3. There should be 3 here. I may not have included the 3rd one, it looks like. First, you're going to send a notice of the default and a notice of the dishonor. Okay? Now, that gets sent from the notary. The notary said that if in 10 days or in 14 days I don't get your response, I'm going to certify your non-response. So the notary, as a friendly reminder, now, who prepares this document? You do. Okay? So this notice of default, the notary signs and seals it, you prepare it, and it basically has all the information on it that's going to be on your certificate. Okay? That on such and such a date, this person, in care of this address, presented these documents, dated this date to this person, signed by this person, requesting And actually, I'll read through this one since it actually is relevant to what we had. So you see up here at the top, State of California, County of Orange, and it's got a little subscribed and sworn. What do you usually see that at the top of? Affidavits. Affidavits. Whenever a notary, a lot of times you'll see it in a notary's acknowledgement. And what does the last line of the acknowledgement say? I declare under penalties of perjury that the foregoing paragraph is true and correct. That's a mini affidavit. A notary acknowledgement is a mini affidavit. That's why it's got this little heading at the top. Okay, so notice of default. Presentment. Be it known that the person signing below a duly empowered notary public at the request of John Henry Smith, in care of the notary's address, did duly present on October 14th the instruments, request regarding a statement of account, and commercial affidavit. Dated October 14th to Tom Jackson of BAA&C Home Finance, 101 Yorktown City, State. That was under the subheading presentment, all that what I read. The next subheading is protest. You guys have heard of a notice of protest or a certificate of protest? Protest. Whereupon the notary public signing below for the reason dishonor by non-performance / non-response does publicly and solemnly certify the dishonor as against all parties it may concern for default on the instruments by reason of non-performance / non-response thereof and the stipulations therein. So remember we were talking about how the letter of presentment had stipulations in it of what we would accept as a response. But your affidavit could also have what we would accept as a response. And your request regarding a statement of account could have the same thing. Okay? And then, so now we've got presentment, we've got protest, and the next subheading, notice. The undersigned notary public certifies that on November 6th, this is after the presentment date, so this is after they have defaulted, notices of default were sent to the parties noted below by depositing in a depository of the United States Postal Service within the state indicated herein a sealed envelope containing said notices directed to the respective persons or entities at the last known corresponding address below. Name of who we presented it to, address of where we presented it. Last subheading, testimony. So this has 4 elements to it: presentment, protest, notice, and testimony. Your certificate of dishonor or protest has those same exact elements. Okay? This is actually the notice of default it's talking about on the notice line. This is it. Okay? Testimony. In testimony of the above, I have signed my name and attached my official seal. In testimony of the above. What's she doing? Witnessing. Okay? And with that notice of default will go a certificate of service. Certificate of service is going to have the notice of default listed and the certificate of service listed. The certificate of service lists everything in the envelope. If you put another envelope in the envelope, that envelope is listed on here. Okay? So, and the way I do it is right here, I always have the certificate of protest as the last item on the list. And right here it says, number 2, because there's only 2 items, reference copy of this notary's certificate of service, in parentheses, signed original on file. So I don't even send them a signed certificate of service. Oh, we're out. Okay, we need to switch the tape.